Hi, this is Rahul Reddy. We are here live from Reddy Newman PC from Houston, Texas. Along with me is Emily Newman. Emily?
Thanks for joining us today. We wanted to bring you an update regarding the H-4 EAD litigation that's been ongoing. There was a new filing with the court today, so we'll talk about that a little bit. We're seeing a lot of issues that people are not aware of regarding travel when their passport is expiring before their approval notice is expiring, and what kind of issues can come from that. So we wanted to talk about that a little bit. We're also nearing the 1-year mark from when USCIS issued its policy memo regarding its ability to deny petitions without issuing a request for evidence. Where are we at 1 year later? How has that memo really impacted things? And then we also want to answer your questions and touch base a little bit about, we've been hearing from H-1B applicants who filed in the lottery this year who are realizing that the employer that sponsored them may have filed fraudulent applications, and they're wondering kind of what their recourse is, what can be done about that. So we wanted to answer some questions on that as well.
I mean, on the H-4 EAD, we already know that the administration wants to eliminate the H-4 EAD. They're intentionally delaying it, violating their own regulations, that they should be adjudicating the H-4 EADs in 1 month, and which they were previously adjudicating along with the H-1B, H-4 and H-4 EADs, and they're not adjudicating it. And we have to go to the court to get these approvals so that these people can continue employment or not lose employment for long term. However, now the USCIS has updated on the regulations on which they are going to give a proposal to eliminate the H-4 EAD, and they updated the code. What did they update in the code? And does it mean that immediately the H-4 EADs will be canceled, or what is going to happen?
Yeah, the update wasn't much of an update. It was the court required the Immigration Service to let them know what the status is on this proposed regulation, because it's been stuck with the OMB for quite some time. We've been expecting it for a long time and it's just not moving, so the court asked for an update. And the update basically just said it's pending with OMB. We've been meeting with 8 different groups and trying to figure out the best way to proceed, and it's with OMB. That's about it. So it really wasn't a big announcement or anything like that, which DHS has rarely submitted any major breaking news in response to this litigation. So the H-4 EAD is still valid, it's still fine, you can still file, you can still get your extensions. This is just one step in the litigation process that's been going on for years now, and the next part of the litigation is going to be oral arguments. As of right now, that's scheduled for the end of September. So we'll at that point see what the government plans on arguing. Just a reminder, the government actually has to argue in support of the H-4 EAD, or at least explain what's going on with the regulation and what's been taking so long, where they stand on that. And of course, the Save Jobs is against the H-4 EAD. So it's kind of an interesting litigation because the government's really not supporting its own regulation, but they want to make sure that the court doesn't invalidate the regulation, because that would restrict the government from being able to issue
any more regulations
that provide for employment authorization without going through Congress. So that's kind of why the government is kind of supporting it, but not really.
Emily, on the travel, when the passport is expiring soon, I mean, if I have my H-1B stamping until 2022 and my H-1B stamping is expiring in 2022, my passport is only expiring in 2020. If I'm coming in December of 2019, I can't enter into the United States, or what are you telling?
Yeah, you can still enter. That's not the problem. But when you enter, you're going to be given an I-94 that's only valid until when your passport expires, not when your visa expires. And a lot of people don't realize that, because now the I-94 system is all online. People forget to check their I-94 when they enter. And so you need to understand that if your passport is expiring before your visa and you're traveling into the country, your I-94 is going to get cut short, and you have to either travel again or file an extension before the shortened I-94 expires. If you think that you have more time, and you stay beyond when your I-94 expired thinking that your visa is valid longer, you're actually unlawfully present during that time. And if you're staying more than 180 days, now you're triggering a 3-year bar potentially. So this has huge consequences and no one really knows about it.
For a simple, easy thing that they can resolve it, you're telling if the I-94 is expiring in 2020 because of the passport visa, all they need to do is that have a nice Cancun trip to Mexico with their passport visa stamped and come back. That's an easy way of solution, not dealing with lawyers. The other way is to filing an extension, which typically I would probably go to Cancun rather than go to a lawyer. But in some circumstances, if somebody physically cannot travel, they may actually file the extension. So please be careful. We see these mistakes. These are something that are so simple that you can avoid these mistakes. We recommend that you always notice the I-94. And whenever you enter into the United States, as soon as you enter into the United States, check your I-94 online. You know how to check online. Sometimes it takes 2 or 3 days to come in online, so please check it. If there is any problem, it's easy to resolve it when you enter immediately rather than resolving it afterwards. Emily, last year on September 11th, exactly 1 year ago, the new memo went into effect that the USCIS may deny the applications without issuing an RFE. Have you seen that in business immigration? Have you seen any of those things happening?
No, I've never seen an application for like an H-1B, an I-129 petition denied without an RFE after that memo came out. Of course, we ensure that we include all of the required initial evidence in our filings, but even if something is missing for some reason, I don't think anyone has really seen any denials based on that memo.
But this memo is mostly for people like who are not even green card holders. Let me apply for naturalization, throw an application to see. Well, I'm on visiting visa, I'll throw an application and then see if my naturalization gets approved. Mostly it's meant for those kind of people, those kind of applications, but not the kind of business visa applications that this YouTube subscribers and the Facebook subscribers that our channel has. I don't think so any of you guys will be affected mostly with this. If we haven't, as Emily has pointed out, we haven't seen any denials without RFEs. Especially when the memo came in, we had a lot of question. If the end client letter is not there, if the vendor letter is not there, will the H-1B will be denied? At that point of time, we said no, it will not be denied, and that has been true. Nothing has been denied without RFE. Emily, on the H-1Bs, that some of the bad employers are filing the H-1Bs. They are filing in cases where they don't even have an in-house project, they're filing in-house projects. And the victims of them, the poor victims of these people, they get their H-1B approved, they move on to company B, and now their H-1B gets revoked. They're completely out of status. They can't even move to another employer because the first H-1B is. What solutions do you offer for them?
Yeah, we've really been looking into this because we're hearing about it more and more, especially as USCIS is going back and revoking the initial H-1B approval, and it's leaving person without status. They're now not counted in the cap. They have to go through the lottery again, potentially unlawfully present that whole time. It is a huge problem for the employee for something that they had no control over or no knowledge of. So we are working with a litigation attorney and are looking at, if we have to, we're going to sue these employers on behalf of the employees for, what these employers have caused to the employees without the employee having any knowledge or involvement. So if you're in that situation where you find out that a petition that was filed on your behalf is not a valid petition, we're talking typically what we see is the employer says, yeah, I'll file your H-1B for you, it's, don't worry about it. And you start asking details and they say, oh, it's an in-house project, don't worry about it. And then there really is no in-house project there at all. We've seen them where the company doesn't even have an office. They're filing petitions out of their house for a true in-house project. It's in their house, but it doesn't exist. And so we're looking at bringing these employers to justice in court.
Yeah, and then we are looking is on a contingent basis. Our office wants to take these things so that it's not a big burden for the people to go after the employers. It's going to be good because people have lost years of their salary because of the bad activities done by the employers. You may contact our office or any other civil litigation lawyer. You may want to check with them to see if this is a case that they can take it to the court and recover any of the money. Emily, let's go to the Q&As that we have. And for those people who are streaming live, you can always put a question on Facebook or YouTube. We're going to try to answer as much as possible. And if any of you guys we are unable to answer, we do have a daily conference call. We also do have a you can also consult us by going to RN Law Group. All of our lawyers' appointments are available online, and you can check our details and make an appointment at any point of time. Anam has this question from Facebook: how long it's taking for an EAD extension? I'm assuming that it's a H-4 EAD. H-4 EAD is taking, H-4 EAD, if it's filed along with the H-4 plus EAD, is taking anywhere between 5 months to 10 months. If you go through the litigation process, once you file the litigation, from around 20 to 40 days, most of the cases get approved. But yeah, it may take up to 60 days if you file the litigation. Reddy and Newman PC has come up to cut down the cost. We group up a lot of people together and file litigation. We do batches of every 2 weeks. We file one batch of litigation to get these things expedited. Now, it's not technically expedited when we are going to the litigation because according to law, they are supposed to adjudicate the EAD application in 30 days. And they said when they asked for the money, they went to the Office of Management and Budget. They said the filing fees that you are submitting is enough to adjudicate it, and they should take about 15 minutes for them to adjudicate that. And they are not following their own proposals, what they have given, and the approvals they got from the Office of Management. All we are doing is go to the court, look, the administration is not doing their job, please have them do the job. And it's an easy way. You go to court and get that approval to expedite the matters.
Dhruvesh from YouTube has noticed he received his H-1B approval, but he noticed that the online case status does not mention that the H-1B has been approved. So I'm assuming it still says H-1B or I-129 petition received, or maybe there was a request for evidence and that says the response was received. Is that something to worry about? No, it's not. This is very common. We see it every year, especially with the CAP cases that were filed in April. The online case status is a bit glitchy. So if you have the approval notice in your hand, you don't need to worry about what it says on the online case status. It is approved.
My husband's primary has received a 485 green card approval 2 weeks back. We haven't received the green card application. This question comes from Utkarsha from YouTube. 2 weeks is a very short period of time. If you have received an online status saying the 485 is approved, it may take up to between 2 weeks to about 8 weeks it takes for you to get the green card in your hand.
Riaz from Facebook wants to know if you can travel while the H-4 EAD renewal is in progress. Yes, very likely that is possible. So one, it depends on, are you filing the H-4 and the EAD or just the EAD? So that would be one question we would need to know. But generally, you have to be in the United States at the time of filing the EAD. And if you travel while it's pending, it has no impact on whether the EAD can be approved or not. Now, the other issue is that if this is an H-4 extension that's pending along with it, you could potentially leave the country, apply for an H-4 visa stamp instead of waiting for the H-4 approval notice, and then come back into the country and wait for the EAD. So generally, travel in that situation is not a problem as long as you were in the U.S. on the time of filing. That would be different if this was a change of status that was pending. If you travel while that's pending, it would abandon the application and cause a denial.
Neeraj from YouTube has this question that he has filed a H-1B amendment for his wife has been filed so that she can work from home, and she got an RFE. Neeraj, welcome to the group. I mean, this is an RFE era and denial era. If just because you filed an amendment, just she changed the job location, yeah, it is typical that they may issue an RFE if she's working from home. By any chance, if the RFE, the H-1B gets denied, you do have a chance to refile the H-1B application, or you do have a chance of, she does have a chance of going back and working from her previous office location where she was working at. But yeah, RFEs have become a norm nowadays. You know, back in previously before 2016, they used to come not this frequently as much as they are. And back in olden days when I started practicing, when I used to get an RFE, it's like, wow, I got an RFE, how do I respond? Poor guy, the employee used to be very tense too. But unfortunately, it has become very common right now. Neeraj, you also need to take the RFE very seriously at respond, even though you have submitted the same documentation before, the same end client, the same information. They're not going to just go by the previous approval, and then we did approve all the things, we are just approving the location. No, that's not. They're going to re-adjudicate the entire application and will not, the previous approval may or may not be effective. So you have to answer the RFE just as if that it's a fresh H-1B.
Harish from Facebook has an H-1B approval that starts from October 1st, but now has a job offer to move to a different company and wants to know if he can file a transfer from October 1st. So assuming that the initial H-1B that's approved was a valid petition, not one of those fraudulent filings that we talked about earlier, yes, you are eligible to file a transfer on October 1st or within the next 60 days and start working for the new employer once that's filed.
Emily, the question on the H-4 EAD again, is it still there or is it taken off? This question is coming many times here.
Yeah, the H-4 EAD is still there. Nothing has changed. The filing in the court today did absolutely nothing. It was just a status update to the court, letting them know what their plans are. You can still file the H-4 EAD. You can still get it approved. You can still file renewals. You can file new ones. Nothing has changed.
Sirish has this question, was there any EADs that we have after 60 days of filing the litigation that has not been approved? Sirish, out of the 200 cases that have come to that 60 days, 2 of the cases did not get approved. The USCIS has requested to ask us a 60 days extension for us because there are some technical problems with those 2 rare H-4 EADs. We have only given them permission for 30 days for them to act on it. Those are only 2 cases out of the number of cases that we have filed that are still pending. The USCIS is diligently working on adjudicating, but they have some technical problems why they couldn't update it. And that's the reason they requested us to respond to the litigation for 60 days. But our office only gave them 30 days time for them to respond.
Divya from Facebook has a standalone H-4 EAD renewal pending at the Vermont Service Center for over 5 months. It was filed April 9th, and the processing time report on the USCIS website shows that normal processing time is April 11th, and she wants to know, is there any way to contact USCIS? Yes. If yours was filed before the date that's showing on their processing time report, you have 2 ways to contact USCIS. You can either call the 1-800 customer service number and wait on hold forever, and then talk to someone who's going to tell you that your H-4 EAD is pending, and that's about it. Or you can submit an e-request online, where you'll fill out a form with all of the filing date, the receipt date, your name, your address, and select the box for outside normal processing time. They'll tell you when to expect a response, and then you'll get a response by email and usually by mail also, letting you know what the status of the case is. Now, the calling customer service or the e-request really doesn't do anything to speed up the process. It just reminds them that your case is still pending and it appears to be outside normal processing time, and then usually in response they'll tell you when you can expect to hear something. It's usually, they say, 60 days, so it doesn't really help anything, but it doesn't hurt to do that just to make sure that they know it's outside normal processing time.
Vishwas from the YouTube has a question. He has the he's an H-1B, his I-140 is approved. Can he buy a small business with a commercial real estate building? Can he own a small real estate building, commercial real estate building? I wouldn't recommend that because commercial real estate building involves your personal involvement. Now, if you are completely not involved in the management of the building, which I can't see how you cannot not involve in it, I would recommend you stay away from those things. We have seen recently a lot of cases where things go successfully. Somebody files a court case on it, which is not that hard, and some small tenant breaching the lease, you want to file a case, or the other way around, and then you were stuck with it. We are just telling people not to own anything commercial at this point of time. Please check with your lawyer if you're an H-1B, if you want to own any commercial property. Yeah, buying your own home, definitely we don't have a problem with it.
Ashwin from Facebook has an H-1B and H-4 and EAD extension pending right now, and his wife's EAD has already expired. He wants to know if she can continue working while the EAD renewal is in process. Unfortunately, the answer is no. Once her EAD expired, she had to stop working and cannot start again until she receives the new EAD card in the mail. The H-4 EAD does not allow you to continue working based on a receipt notice. It's not like an H-1B extension. It's also not like a STEM OPT extension, and it's not like an adjustment of status EAD renewal. Those do allow you to work for up to 180 days based on a pending application. The H-4 EAD does not, unfortunately.
Sirisha has this question, Sriram has this question from YouTube that his I-140 has been withdrawn. It's been after 6 months of approval. He did not work for that company for a whole 6 months period, but his I-140 was actually withdrawn after the 6 months period. Does that I-140 is valid for him to use for the H-1B extensions, EADs? The answer to the question is yes, Sriram, you can use it. There is no requirement that you must have worked with the company for 180 days. The only requirement is that the I-140 must not have been withdrawn until after 180 days is over. There's no requirement that you must work for that company in that period of time.
Nikhil from YouTube wants to know, what is an expert opinion letter? Is it required to submit if you have received a request for evidence on specialty occupation? So an expert opinion letter is something that we as attorneys, we often recommend when you get certain types of requests for evidence. You're basically asking an expert in the industry to review the situation and give their opinion on what the job requires. So specifically for specialty occupation, we will often have the expert review the job description, take a look at the company, talk to officials with the company to understand more about what the company does and what the job does. They're going to review that and give their expert opinion on what education is normally required for that job. So that helps when the expert says, I've reviewed these job duties, I'm aware of this company, I know what they do, and based on my expertise, I think this job normally requires a bachelor's degree in mechanical engineering or whatever it is. And then you submit that in response to the request for evidence to show that this is the industry standard for similar jobs out there. That's one way to prove that a position is a specialty occupation. We recommend it in most of our specialty occupation type of requests for evidence. It's a very good piece of evidence to submit. They can be expensive, but it's well worth it.
Kiran has this question from YouTube. What is the process of litigation? He has filed his H-4 EAD on 2019. I would recommend that you can go back to the previous videos that we have, or you can drop an email at info@rnlawgroup.com. I'll send an email detailing how the litigation process works. Unfortunately, we don't give the exact figure of the fees that we charge on the YouTube or any recorded line. That's our office policy. I can't do that. And we have this question from Upula. I need your attention on it. By how many days should I file an amendment after changing the job location?
Unfortunately, the matter of Simeo guidance requires that the amendment has to be filed. It has to. There's no ifs, ands, or buts about it. It has to be filed before you can start at the new location. So So unfortunately, by moving to the new location, if without filing an amendment, you may be violating your status. Definitely discuss with your lawyer right away to figure out if there's a way to cure that violation, because that can cause major problems.
Srikant asks this question: if he moves to a different client within the same MSA, within the same geographical area, but I'm assuming that it's MSA, does he need to file an amendment? This question comes from Srikant from Facebook. You may not need an amendment if the job duties are similar. Job duties don't have to be exactly matching, but if the job duties are similar, if you are within the same MSA, you may not need the amendment. If the FDNS, which is the fraud detection unit, comes, you can always check you moved into within the same MSA, matter of same use solution, doesn't require an amendment if it is a similar job within the same MSA. However, though, if you were to go for stamping, though, we strongly recommend that you get the amendment done before you go for stamping, because on the record they don't have the new client. The consulates are hesitant in giving the stamping when you don't file an amendment, even though it's in the same MSA.
I have a question for you, Rahul. This comes from Ashok on Facebook. Any updates on S386?
No discussions are going on S386. I see that some more questions are there on the HR 1044, which is also which is passed in the House, and now it's pending in Senate. We know that Senator Rand Paul put a block on it. It requires 60 votes to overthrow that block. We haven't seen that coming from Senate. This is a drama that goes on, Emily. I mean, from the time I've been practicing immigration law, the Senate and House, they keep on playing. One time the Senate passes, the House doesn't pass. One time the House passes, the Senate doesn't pass. And unfortunately, it's not just the immigration that is suffering. It's the same thing that the entire Congress is right now. And it's just dead. They don't do anything. If this one passes, that one doesn't pass. There are some pitfalls in this country. As you know, I'm a jurisprudence student. I have studied a lot of constitutions in different Australia, India, and England, and other thing. And there are a lot of pluses in this jurisprudence of United States. This one point is that there is no uniformity in the administration and the legislation. They're completely segregated in United States. The executive branch and the legislative branch are completely segregated, and that segregation has a lot of advantage, and this is one of the disadvantages, is that the legislation is not in hand with the administration. And within the legislation, there are two branches there, which is not two branches. Within there's like lower house and upper house. Upper house is called as the Senate, and the lower house is called House of Representatives here. And unfortunately, there is no uniformity within the same legislative branch of United States. Every time, most of the time, the House and Senate are indifferent. Even when both belong to the same party, there is no rule called whip, which is there in most of the other parliamentarian countries, and that's the one which is lacking in United States. It's definitely one of the big pitfalls that we have in this jurisprudence of this country. So yes, it's passed in the House, it's stuck in the Senate. There are so many bills that passed in the Senate that get stuck. There is nothing we can do at this point of time.
Proban has a question from YouTube. Really good question, since we talked about traveling while a passport is expiring. So in his situation, he's got the H-1B that's valid until October of 2021. His passport is expiring in May of 2022. He's not asking about travel, but he wants to know when he files his H-1 extension in 2021, is it going to get cut short because his passport is expiring before 3 years? And the answer is no. You need your passport to be valid at the time of filing the extension, but if it expires before the 3-year period requesting, you're still eligible for the 3-year period. So they don't cut short your extension when you're filing with USCIS based on a passport. They just cut short your entry, your I-94, when you enter the country. So that's a really good question.
One question came from Neeti Sharma from Facebook, is that she has an 18-year-old H-4 dependent. Can the dependent apply for EAD? I'm assuming, Neeti, you're speaking about your kid, not your husband. My husband can be 18 too, maybe, I don't know. But I'm assuming, no, it's kid you have. Unless, correct me if I'm wrong, Niti Sharma from Facebook. No, the kids are not eligible for the H-4 EAD. Only spouse is eligible for H-4 EAD.
Neeraj on YouTube has a question. I'm guessing he entered the U.S. from the Canada border yesterday, and his I-94 has not shown up yet with the updated information. He wants to know if it takes a while. That sometimes can take a couple of days, but you also have to be aware that when you're traveling to the U.S. from Canada by car, they may not actually update your I-94 online. So if usually they do when you're traveling by air, but if you're coming through by car, you might never see that updated. So just keep copies of any travel documentation you have, car rental, credit card receipts to show that travel and that entry on that specific day in case you need it for later filing your adjustment of status or something like that.
One question Jasmine Kumar has is, do you have any updates on the August 30th, 2019 litigation that we filed? Jasmine, we haven't checked it. That's too early for us to check the August 30th, 2019. Typically, most of the approvals we receive is between 20 and 40 days. Yes, there are some that comes before, there are some that comes afterwards, but typically we see between 20 and 40 days. On 60th day, the USCIS have to give explanation why they are delaying, if they're any delaying. As of now, very rarely we see anything where the USCIS asks for excuse. They are adjudicating almost all cases within 60 days. Yeah, but within 6 days or 10 days, yeah, very rarely we do get the approvals once we file the litigation.
Amit from YouTube has a situation with his STEM OPT. He recently changed employers while he's on the STEM OPT and just now realized that the new employer is not an E-Verify company. So in order to have a STEM extension and be working on that OPT, the employer has to be an E-Verify company. So unfortunately that is a violation of status, even though you didn't know it until recently. So you definitely need to discuss with an attorney right away and look at the time frame for how long you worked there. It is a violation of F1 status, and it may require travel in order to clear that up so that in the future it will not impact you when you're filing your green card or when you're filing anything else. Be aware also when you are, if you do travel in the future and are applying for a new visa stamp, the DS-160 application asks, have you ever violated your status? I think you're going to have to answer yes. You always have to answer that question truthfully and provide the information. So yes, this could be a problem, but it should be fixable, but you have to take action right away.
Neha Sharma has this question that how much time it's taking to move from H4 to F1, what steps need to be taken, especially she's having some marital issues, maybe forced out. One, Neha, is that F1 is taking between 8 months to approximately around 18 months. The problem here, Neha, is that you have to have your maintained status until your F1 is approved. So if your H4 is expiring or if your divorce proceedings become final, you may be in trouble in getting the F1. Unlike some other visas, when you apply for F1, you have to maintain the visa status until the H4, until the F1 is approved. This also goes to Niti Sharma, who asked about, not Neha Sharma, but Niti Sharma, who asked about her kid H4 EAD, which she cannot get it. Niti, you may also want to be very careful. If the kid is turned 18, you may want to think about applying the F1 visa somewhere when the kid is about 19-year-old. Don't wait until he's 20, because at 21 he'll be out, and his F1, if it's not approved, he may have a trouble. So I normally recommend people, as soon as they go to college, apply for the F1 visa. Don't wait until they become 20 to apply for the F1 visa.
Prasant from YouTube wants to know, after changing employers on an H-1 visa, so you file your transfer and get a new approval notice with the new I-94 on it, do I need to get my driver's license reissued because that's based on the previous employer's I-94 number and the I-94 number may have changed? The answer is no, as long as your driver's license has not expired and you didn't move out of state, that driver's license remains valid. So when it's expiring and it's time to renew, you'll show your new employer's approval notice at that time. As far as I-94 numbers, the I-94 number shouldn't change when you file a transfer. It only changes when you travel and enter the U.S. and get a new I-94 issued through CBP.
Smita has this question: can the litigation be filed for H-4 extension as well as H-4 EAD? Yes, it's for both. It's not for one. There are some cases where the H-4 is already approved, and then we could just go for litigation only for EAD. But when we are going for litigation for EAD, if the H-4 is pending, we attach both the things to go for the H-4 EAD litigation.
Gayatri from YouTube wants to know if there were any RFEs or many RFEs issued for computer systems analyst jobs for H-1 extensions, and what is the chance of approval after a request for evidence? So yes, definitely, if you are filing an H-1B, whether it's an extension, a transfer, amendment, or new petition using the computer systems analyst, you can expect a request for evidence on that. Just because the Occupational Outlook Handbook is not very, doesn't have very good language for the specialty occupation issue for H-1Bs. Chances of approval really depend on the situation. It depends partly on the wage level, depends on the job duties themselves. It depends on what the employer states its normal education requirement is for the position, whether they have other employees that they've hired in the past in that position who all have the same field of study for their degrees. So it can be approved, but there are also chances it can be denied, just depending on the specifics of the job offer.
Deepak has this question from YouTube: can H-4, have you ever seen a H-4 EAD denied? I have to admit, I have once came across the H-4 EAD denied. The reason being, they sent an RFE saying that the passport size pictures are not there in the H-4 EAD application, and the client responded saying that I have given the H-4 EAD passport size pictures before, I'm not going to give it to you again, and responded to the RFE, and they denied the H-4 EAD. I mean, my advice would have been that just give it to them what they're asking. Don't try to confront. But anyway, that came afterwards. Very rarely we see any denials of H-4 EAD. Unless there is something fundamentally very wrong, I don't see the H-4 EAD denials. My H-1B got picked up. Right now I'm an H-4 EAD. How do I do the change of status? If the this is a question that comes from Facebook from Krupal. If you are in H-4 and you did not apply for change of status, you get a H-1B approval, you may want to apply for change of status again, one more application. I would have applied for the change of status application initially itself when you applied for the H-1B. But if it's not, you may want to have something interfiling and request to the USCIS to see if they're going to go for change of status. But we have noticed that when we do that, they're not approving the change of status. They still give the consular processing, but you may try to do that thing. If that doesn't work, you can apply for the change of status or go outside the country and come back into the United States.
Shreyas from YouTube has an approved H-1B. His wife's H-4 extension is still pending, and he wants to know if we go to India, can she get her visa stamp and come back? So yes, since her H-4 was timely filed, the extension was before her I-94 expires, she'll carry your H-1B approval notice and a copy of her H-4 receipt notice to show that she maintained her status while she was in the U.S. She can get the H-4 stamped based on your H-1 approval notice and come back into the U.S. and therefore avoid waiting for the I-539 to process.
One same follow-up question, Emily. While the H-1B is pending, can the H-4 apply in the visa consulate? And then go for the visa interview after the H-1B is approved.
To submit the DS-160?
Right.
Well, you definitely need the case number to be able to submit
I can provide the receipt number.
Yeah.
I don't see any problem in that,
yeah. The only issue would be the timing. What if you schedule a date and it's not approved yet.
Oh, it's not approved, they'll withdraw the application.
Yeah, so then you've wasted your
They don't,
your
believe me,
application.
they don't care about,
But yeah, I know getting that appointment earlier
is important.
Tough right
it's
now.
It's a good question. I don't see any problem in making an appointment with the receipt notice. This comes from Smita Lohi from Facebook, is that, yeah, I would make an appointment, and if by any chance the denial comes in or RFE comes in, it goes beyond, I'll withdraw the application. I won't care about the money because it's taking about 2 to 3 months in India to get an appointment. I may do it. I don't see any problem in it. Good question, Smita.
Raj from YouTube is on EAD with a pending 485 based on the EB1 category, already been interviewed for the 485 and wants to know if he can switch jobs at this point. So once the 485 has been pending for at least 180 days, you're eligible to change jobs to a new employer as long as the new job is in the same or similar occupational category as the job that you were sponsored for. So assuming that you're moving to a similar position, even though you already had your interview, you'll have to submit the I-485 Supplement J and prove that the new job is similar to the old job, and then the whole green card process will move with you to that new employer.
Ms. Sharma from Facebook has a follow-up question, Emily, which is a good follow-up question, is that if her kid, who is 18-year-old, moves to F1 visa, can he apply for the adjustment of status once the priority date becomes current? Yes, they don't have to be an H-4 to file an adjustment of status. If they're an F1, they can file. They need to be under 21 years old. Of course, there are some limitations or exceptions under the Family Protection Act where you have certain leeway if they are above 21, which I'm not going to discuss further on this one. But if they are under 21, if they are an F1 visa, absolutely no problem. You can file adjustment of status.
Sneha from Facebook wants to know, she has an approved I-140 and it's been approved for more than 6 months. In case I lose my job and the current employer revokes my H-1B, can I still use the current H-1B and I-140 to work for another employer? So if you lose your job and you have not filed a transfer yet and the old employer revokes your H-1B, that means they've requested to withdraw it, and in response to USCIS is the one that revokes it. If you can find a new employer and file a transfer within the 60-day grace period, you can transfer to the new employer and work for the new employer. Since the I-140 was approved for more than 6 months, you can use that I-140 to get up to 3-year extensions again and again with the new employer or any other employer in the future. You can keep that priority date when you file a new labor certification, a new I-140 with your new employer. So yes, you can definitely take all of that with you and continue your status with the new company.
One interesting question I want your attention, Emily, is that this gentleman got a Canadian green card. He has a H-1B. Can he work 3 weeks in United States and 3 weeks in Canada? Does he need any amendment to be done?
I don't think so. I mean, if
no.
you're in Canada,
You're in Canada,
U.S. immigration law doesn't apply to you.
Yeah, you can sit in Canada as long as the Canada allows you to work, and assuming that you're a Canadian green card, absolutely no problem. You can work in Canada. You don't need any amendment to work in Canada.
And you can recapture all that time you spend there.
Yeah, if you don't have I-140 approval. Jahab from YouTube has this question. Can I go to Germany, Canada, or Mexico instead of going to India to get the stamping? Canada and Mexico does allow third country nationals. Not all the time, most of the times they do allow the third country nationals to apply for the visa. Now, when it comes to the Germany though, they do not, the US consulates in Germany do not allow third country nationals to apply for the visa status unless you are residing in Germany. There are some exceptions available, but mostly they don't. Mostly the US consulates in Canada and Mexico are equipped with the third country national system. But in Germany, they're not equipped with that much. So Germany is no unless there is some exception available there.
Arun from Facebook wants to know how to apply for an expedite process for an H-4 EAD. Well, you can certainly apply for it, but I'll tell you, since March, I've not seen one expedite request be approved.
A bot response to them. Your expedited request has been denied. And before that, sometimes they ask, the bot will tell, submit additional documents. While the guy is so happy, and I have had people who are surgeons and who have surgery scheduled, not for them, but for their patient. And the bot responds, your expedited thing has been denied. So we are, the easy way right now seems to be litigation. When we understand that, it still is not a very shortcut process where you're going to get it in 2 weeks, but it definitely is better way than keep on going after the expedited process. At this point of time, all the people who are having H-4 EAD, almost 70% of them are requesting expedited process, and they are making that as an excuse to delay their H-4 EADs more right now.
Varun from Facebook has been hearing that USCIS has been issuing an RFE in most H-1B extensions that are filed in premium. Is that true?
No, it may be true that they are issuing RFEs in most of the cases, but we don't see any truth in that premium processing is getting the RFEs. Premium process is not getting more RFEs. Premium process is not getting more denials. However, we'll say that you're getting the RFE faster. You may be getting the denial faster. That's all. You're getting the approval also faster too. So premium processing, I don't know, this rumor, where it just keeps floating around, keeps coming around every other week, saying that premium processing gets you the things. I mean, immigration wants your money. I mean, and there are, at one point of time, there was a rumor that if you file in premium processing, you get into the lottery system much better. So we have seen all kind of rumors going around. There is no truth in it. It will be a complete violation of the Administrative Practices Act by USCIS if they do it. And we haven't seen them doing it. It's just a rumor. When we look into our stats, it doesn't tally what you're telling.
VJ has an L1 extension that is pending and is expecting the result of that soon. He also has an approved change of status to H-1B from another employer, and he wants to know what to do if the L1B extension gets denied. Well, it really depends on when your current L1 expires. I'm assuming that it expires after October 1st. And in that situation, you can continue working for your L1 employer up until the date your current L1 expires, and then October 1st, you need to start working for the other employer because your H-1B's change of status kicks in. Now, if your current L1 expires before October 1st, I think the change of status may have been issued in error, so I would definitely look into that, but then you won't be able to stay between the expiration of that I-94 and the start date of the H-1 because you'll have no status in between.
Avinash has this question. I am an H-1B EB2 I-140. Approved priority date is June 2012. Is it a good idea to switch to EB1? Yeah, if you get one EB1, if you're eligible for EB1, you can switch to EB1 and put the date to EB1. However, though, EB1 is not as easy as EB2 or EB3. This is a tough process that requires, there are 3 EB1, EB1A, which is extraordinary ability, and there are some easy ways to qualify and get an Oscar or Nobel Prize or even get a nomination, you're in. But there are hard ways to qualify, and those are very hard, strict rules. And outstanding researcher and also multinational manager. A lot of people will, oh, I am a multinational manager, I'm a high-level manager, I'll come into. There's another requirement. You must have worked for that company outside the country for at least 1 year before you work for this company here. So it's not an easy way to qualify. If you think you may be qualified for any of the EB1, don't count on it. I would recommend you contact a lawyer and get an evaluation done. Is it something feasible? Am I dreaming these things? Most of the time, I would say that 95% of the time, we would say that we take the money and tell them you're not qualified for this. But it may be worth for you to get evaluated, because if I were to plan my family in this country, yeah, I want to evaluate whether or not. But just go look into online to see. Radian Newman PC has a good requirement where you can go and read it and see if you marginally fit into those things. You can go at rnlawgroup.com and try to look into the EB1 there.
Ankit from YouTube currently is on F1 status with a STEM EAD that just got approved. Hasn't gotten the card in the mail yet. He needs to travel due to a family situation and wants to know how risky is it to get the F1 visa stamp because his stamp is expired. Do you think he'll be able to come back in?
I wouldn't recommend it at all. I wouldn't recommend it. If the stamp is expired, you're going and his EAD is pending. I understand the situation. I come from the same country. It's very hard for you to get the stamping. The consulates give F1 visas for you to complete your education and come back. When you're going into STEM extension, which is legally allowed though, but unless you're from Harvard or Yale, I would not recommend going.
Teja from Facebook wants to know if she can apply for the H1 to H4 change of status and the H4 EAD at the same time. And yes, you can do that, but the problem is the processing time. You're stuck with the I-539 processing times. So if you mentioned you're on H-1B, and so you can continue working with your current employer on H-1B while you're waiting for the H-4 and EAD to be approved, but it might take 5, 6, 7, 8 months.
Yeah.
Your other option is to go out, get the H-4 stamp, come in, and then
the
file
EAD
the
is taking
EAD.
6 to 8 months too.
But yeah, that's just
So
long.
if you want it expedited, you may want to join the litigation. But if you're comfortable working it where they are working on, they can continue working on the H-1B if the validity period is there. I mean, there's nothing wrong. Even though H-4 plus EAD is pending, you can continue work on the H-1B even though your EAD is not approved until the H-1B expires with the same company that got the H-1B approval.
Let's see, Sai Kumar from YouTube is on F1 and has already used his OPT and STEM OPT and is currently pursuing a PhD, but has his H-1B petition approved starting October 1st and wants to know what action he needs to take on the PhD studies. Once you're in H-1B status, you don't have to continue to go to school to maintain status, but you could continue if you wanted to, as long as you're able to continue working. So it's your choice at that point.
Rayesh Ansari has this question: can I have 5 to 10 trading transactions? Will it cause any problem in his H-1B or adjustment of status? I'm assuming the trading he's speaking about is online trading, Emily. I don't see that as a problem, Rayesh. I don't think so. You're violating the H-1B by trading 5 or 10 times a day. I don't think so at all. You're violating the H-1B status. Those are normal transactions. I remember that I used to do 60, 70 transactions a day while I was an immigration lawyer. I would say that I did a good investment advice. I'm not going to advise you as an investment guy because I'm a big loser in that. But as an immigration lawyer, I don't see any problem.
Ashwin from Facebook has a good question. Do they check your email account at the port of entry?
Wow.
Yeah, they can check your phone and they can read the emails that are on your phone. They can look at social media. And yeah, we see a lot of people that end up getting into trouble when CBP starts reading their emails and thinking that there's some sort of misrepresentation going on.
Most of our audiences are software guys, and you're writing all these software guys. And this is what Snowden said. The Snowden, the guy who's been in Russia for a while, what he said was that when the iPhone or your smartphone is powered off, it's a recording and it's transmitting that record, and the government things are analyzing those things. At this point of time, if you're believing that your emails and your social media and all those things are not read by the government, well, think again. There is a movie made about 20 years ago when the technology was way, way, way backwards called Enemy of the State. You may want to look at that movie. And that is real. I mean, so they do look into it, and when you come into the port of entry, you may not have that much right of refusing to give your email password, WhatsApp, and WhatsApp is the major danger we look into, because a lot of immigrants, and because of the cross country, they do communicate more on the WhatsApp application than text and email. We know that WhatsApp has as saying it's a scripted thing, nobody can read all those things. Come on, don't believe those things, guys. Everybody, all these intelligence agencies are reading those things. What we see mostly is a WhatsApp, and when you come into it, they look at a WhatsApp, and please be careful on what you're communicating, what you're doing online. Nothing is a secret anymore, guys.
Anoop from YouTube went for visa stamping and got a 221G. The I-797 is expiring in December, and he wants to know what his options are. Well, the 221G could take a couple of weeks. It could take a couple of months. It could ultimately result in the visa being denied and the petition being sent back to USCIS for revocation. Your options kind of depend on whether this was a cap subject H-1B or was this an extension or a transfer filed later. If you are exempt from the cap because you've been counted before, you may be able to file a petition with a different employer. Also kind of depends on what the reason behind the 221G is, which we don't know. We're never going to know that, but maybe it's something that's with that particular employer, and by switching to a different employer, you may have better chances.
Question, this is a technical thing suggested by Joheb from YouTube, is that can I use a burner phone during travel? I don't know what burner phone is, never heard of it. I'm assuming that if somebody touches it, it just disappears.
It's just a throwaway phone. You just buy it for that trip and then you throw it away.
Throw it where? They're in the country.
Well, you throw it away before you come back, so you don't have a phone when you're entering.
Okay, yeah. But still, the record, once you have it, it's on. I don't think so. That's a good idea.
I think I watched too many episodes of Dateline, so I know what burner phones are.
Okay.
That's what a lot of murder suspects seem to have.
Any other questions, Emily?
Let's see here.
Too many questions are coming, but this session that we do, guys, it's not just the education for you guys, but thank you for giving an opportunity. You're also giving us the information so much and trusting us and giving us all the information that gets us a lot of education. To be in touch with the clients is the utmost responsibility of a lawyer. This YouTube and Facebook Live also give a live interaction for us and a good opportunity for us to know what's going on if ever we are missing. And don't forget that we do have a daily conference calls. You can check our daily conference calls at rnlawgroup.com. Don't forget to subscribe RN Law Group news section, and also Immigration Girl, which Emily hosts it. You can subscribe to her news thing.
And yeah, if you want to hear more from us, you can actually see our podcast, which is our daily conference call that's recorded, and you can listen to it on your way to work or whenever you want, every single day. So we do the same thing on the conference call that we do here. We take calls and answer questions, and then we put that all into a podcast for you to listen to.
Thank you guys for coming in. Thank you.
Thanks for joining.